welcome Mr. Gartin. You can start your opening remarks whenever you would like, and I see you brought a guest. If you would like to introduce her, that would be great as well.
Yes, so I brought my wife, Tara. She and I have been married for a little over almost 32 years, and so she's along for the ride today, so I appreciate her support in coming today.
You're welcome.
Chairperson Law and members of the Commission, it's great to be before you today. You've had a long day. This has been a very strong field, and I'm happy to be on the home stretch for you. Thank you for your service in the Commission and the opportunity to appear before you today. I am here because the Iowa Court of Appeals and Supreme Court need a strong transactional lawyer on the team. It can make a difference to the outcome of cases and to the way in which those cases are written. Last week, the Iowa Court of Appeals issued 62 opinions. 9 of them were transactional in nature. And just to review them with you just a little bit to give you a flavor of this. One was an easement case, which I'll talk about in a moment, a petition matter involving transfer on death deeds, how a prenuptial agreement interfaces with a probate matter, the use of a dragnet clause in a mortgage foreclosure, whether there can be reimbursement for expenses where money is paid to an now-deceased parent in a probate matter, 2 drainage district cases, and 2 condemnation proceedings. These are important cases to the people of Iowa. One of the cases I'll talk about in particular is McNaughton versus Chartier. This is an easement case, and it affects many people in Iowa. You see, many people access their property not off of a street or a public road, but off of an easement. Thousands do in rural Iowa. And the issue in this case is whether that easement runs with the land or is in favor of a particular person. And more in particular is whether the easement has to have specific language so that it establishes that it runs with the land. Now, I'm not here today to talk about the merits of that case, but I can tell you that I'm telling you that I would write that opinion differently to provide guidance for the lawyers who draft easements, review easements, and examine abstracts. This is an important case. And just for fun, I brought this along. Some of you may have read Court of Appeals opinions, maybe you haven't, so I brought this along just for reference. This baseball team needs a catcher. Secondly, I'm here because I believe I have the horsepower to handle the volume and complexity of the cases that come before the Court of Appeals. Third, I am here because I believe that my 25 years of service to the community and to the bar in general enhance my ability to provide meaningful review of every case that comes before me. And fourth, I'm here with the support of my amazing family. I meant to introduce my wife. I have 4 adult children and my wonderful law firm. I also stand on the shoulders of wonderful friends and mentors like Dan Moore, George Mattson, Professor Pat Bauer, and Dr. Carl Gwiazda, and 3 who are deceased now, my former law partner Craig Hastings, Federal District Court Judge Jack Dara, and Dr. Louis Hasselmeyer. Many people have made a great investment in me, and I can only hope to repay them in some way. I am ready to be the catcher, and I look forward to your questions.
Okay. Commissioner Sukup, would you like to start?
Okay, thank you. When we visited, asked what was new the last couple of years on some of your work with Iowa State or on the council, city council. Anything new on your aspect that way?
Yeah, thank you. So I have appeared before you, and just to update you, I continue to serve on our city council, and I believe that enhances me as a candidate to serve on the Court of Appeals because we work at the teams, the Court of Appeals works in panels of 3. And so this has given me an opportunity to work with people in making decisions. And I teach a business law class at Iowa State, and I found that to be very rewarding.
Thank you.
Thank you.
Commissioner O'Brien? Could you talk a little bit about your pro bono work through the Volunteer Lawyer Project?
Yeah, thanks for asking that question. So lawyers in Iowa are required, or not required, but strongly encouraged to give 50 hours of service back in pro bono. And this is really shaping. I believe pro bono work isn't just for us to give back, but I believe that pro bono service affects us because it gives us a different set of lenses in which to approach the practice of law. So I have long taken a high volume of pro bono cases, and in my application materials I talk about several of them that have really shaped who I am as an attorney in my practice. But I continue to have these cases. One of them in particular I'm dealing with now is a dispute over a mobile home and whether the title was properly transferred. It was a referral from our local legal aid society. And that case is not going to change the world for the people of the state of Iowa, but it makes a world of difference for the people who are involved. Thanks for asking that question.
Commissioner Pearson?
Good afternoon. Excuse me, good afternoon. Yeah, on your application, you indicate that your judicial philosophy is that you're a textualist and a proponent of judicial restraint. Are there any other additional comments you'd like to make other than what's included on your application?
Yeah, I
regarding those
appreciate that,
areas?
Commissioner Pearson. I do think that the philosophy of the candidates is important. And I identify myself as a textualist because I believe very strongly in this idea of separation of powers. So I would want the legislature to do their job, and our role is to really make the legislature create statutes that are clear. And it's not our role in the appellate courts to create the law. So the courts have a gap-filling function, but to the degree possible, we would want the legislature to be making the law in Iowa.
Thank you.
Yeah, good question.
Commissioner Goodman?
Is there anybody in this building on either floor, either the Supreme Court or the Court of Appeals, that has credentials that resemble yours in transactional real estate work?
Thank you for that question, Commissioner Goodman. I don't know of any, and that's really why I'm here. If I thought that the need of the hour was someone else that has an extensive practice in family law and criminal law, I probably would not have applied. So I've had lawyers all over Iowa reach out to me and encourage me. You have a number of those letters in your packet written on my behalf, and I believe that if you have a law firm that has 15, 16 people, there should be someone in the house that is comfortable with a contract and transactional law, and that's what I would seek to bring to this court.
I have one last question on a comment you made. You talked about the McNaughton case, and you said I would have drafted that opinion differently. I gather from your comment what you mean is you would have been more explanatory about why, so lawyers would understand, not that you would reach a different outcome. Is that correct?
Correct. So I'm going to be real careful not to talk about the substance of a case, but when we write opinions, opinions should be written, first of all, for the parties. It's important if you lose. I've appealed cases and lost, and I just want to know why I've lost. And so that's an important aspect of a decision. But beyond that, these opinions are written to provide guidance to the lawyers who have to figure out what the law is and properly advise their clients. And so I think having a transactional attorney in the Court of Appeals would affect not only the outcome of some of these cases, but just the way in which those cases are written. And I'm not faulting the judge who authored this opinion. They just don't have that background to appreciate what lawyers are going to have to do as a result of this case.
Thank you.
Yeah, thank you.
Commissioner Hanson?
Good afternoon. Tell me about a time you had an ethical dilemma over a case.
Yeah. Well, these things come up once in a while, and I spend a lot of my time teaching ethics, but it can happen to anyone. And one of them in particular is a situation where I represented an individual in a criminal matter, and he went to prison, and that was not my fault, by the way. His own actions got him into prison. And when he returned from Fort Madison, he came back without any support in the community. As a convicted felon, he had a great deal of difficulty finding a job. He was homeless, and honestly, I wanted to help him. And so I reached out to the disciplinary board, and I said, look, I know there's a rule of ethics on this, but financially, I would like to provide some assistance. And I'll never forget how the conversation went. I said, Mr. Gartin, we appreciate your desire to help this gentleman, but you cannot do that. You cannot serve both as his lawyer and his financial help. Because, and I'll never forget this phrase, you will lose what's called your objective detachment. And that phrase has always stuck with me because in areas of conflict of interest, that concept of objective detachment is what allows lawyers to properly advise their clients. Thanks for asking that question.
Commissioner Valentine?
Thank you. Earlier, when you were talking with Ms. Pearson, you mentioned that it's the legislator's job to write clear laws and the court's job to interpret those laws. We all know that the legislators don't always write clear laws.
Mm-hmm.
What is the court to do at that point?
Right. Thank you for that question. Does anyone else have a question? No? I should answer this one. So this is really one of the difficult questions, and I've provided you with an outline I wrote on statutory interpretation that attempts to address this. But I think we should always be very reluctant to do the legislature's job. And one of the questions you'll hear from Justice Gorsuch on the Supreme Court is he'll say, "Counselor, what would be wrong with us just applying the law as it is?" And so that's a sense of the philosophy that I would bring to this work. Now, there are situations where there are words or phrases that are ambiguous, and there are canons of statutory interpretation that we apply in those situations. But as a general starting point, because I believe so strongly in it's a part of my DNA, the separation of powers, I want the legislature to do their job. I don't want to be a quasi-legislator. You see, the legislature has a very difficult task, and it's a very laborious process. I've had a couple of bills go through the process, and it took years to get the bill through. And so we just don't have the tools in the courts to do what the legislature does. So I have a high respect for the work of the legislature. Thanks for that question.
Thank you.
Commissioner Bevel.
You know, I'm trying to ask this question without getting in trouble.
It's just us in here. No one's else paying attention.
No one's preaching.
Yeah, he school's over.
I'll be with you.
Well, you talked about, or you talk about being a textualist and deferring to the legislature. When I hear that, I think back even during my lifetime, when there are statutes that are written that aren't ambiguous, like you ride the back of the bus, or you can't come in here. What do you do in those situations?
Well, I appreciate that question. And it should not get you in trouble, because all of us in this room, whether lawyers or non-lawyers, should care deeply about those issues. And so the work of the Court of Appeals is going to be more heavily involved with statutory interpretation. The Supreme Court generally keeps more of those cases that involve more profound constitutional questions. So there's
Now,
sort of a gatekeeper
so
role.
the Constitution does have a role.
Absolutely.
Okay.
That was the answer you're looking for. Is it Constitution? Yes. But we wouldn't have a Brown versus Board of Education had it not been for the courage of a unanimous Supreme Court to say that what we've been doing for the last 75 years was wrong in overruling Plessy. So your point's very, very salient. Thank you.
Commissioner Hoyting.
You describe yourself as a transactional attorney, but reviewing your application, that's not always been true, correct?
Correct.
Can you describe a little bit of what your previous experience is?
Yeah, thanks for asking that. I went to law school to be a litigator. I didn't think I would go to law school and then come out and handle real estate transactions and wills and probate matters. So for the first 10 years of my practice, I had a very heavy criminal defense docket and a heavy juvenile docket. And I have a deep love affair of those lawyers who step into the courtroom every day and try cases. I miss it. There is nothing I enjoy more than trying cases. And so, but in a small town, sometimes the nature of your work is dictated to you by the realities of having to feed your family. But I deeply have a deep admiration for litigators. Thanks for asking that question.
Thank you.
Commissioner Spies.
Well, to follow up with my colleague, and I don't understand what a textualist is. I've heard it described, but it's also been said that the life of the law lies not in logic, but in experience. And so my question is, where does conscience fit in the judicial reasoning of Judge Gartin?
Justice Holmes opened the path of the law with the quote that Commissioner Spies issued, and it's a fantastic quote. And let me refer to you to a situation that Justice Scalia described on several occasions. he explained that sometimes as a judge, you have to reach decisions that you yourself would not come out with if you were the one in charge of that area, that decision. And he gave the example of the flag burning cases. So he ruled that it was constitutional for someone to burn the American flag, even though he found that practice reprehensible. So I think it's important for the courts to recognize that in some instances, we need to withhold what we ourselves would feel is the right outcome, because that's what the law requires. We are a society of the rule of law. But that's a hard question, and thankfully the
You're
bulk.
in the hot box today.
Pardon me? Yeah,
You're in
that's
the hot box.
that's right. That's right. But thankfully, a lot of the decisions aren't matters of conscience like that. There are certainly some very hot button issues that occasionally a judge will hear, but the bread and butter work thankfully aren't going to involve as many of those. But a judge has to be prepared for those. So I think it's a great question.
Commissioner Sinclair.
No questions.
Commissioner Conover.
Just a comment, the mention of Dr. Carl Guiazda takes me back 25 years to his office at Iowa State. I'm a lawyer because of him,
Wow.
so that's cool.
So that was not planned, by the way. I had no idea.
You drew the short straw.
So Dr. Guiazda was my major professor. I have a master's degree in literature. And when I came back from law school, I asked him, is he reading anything? And he said, well, as a matter of fact, I am. And we read together. We met once a week together for probably 15 years. And Carl is very close to being a father figure to me and has really shaped me because of the reading we did literally every week. And frankly, I think he made me a better lawyer because he really required me to read carefully and closely. And I think these are very important characteristics for lawyers and judges.
Commissioner Mullet.
No questions, thanks.
Commissioner Gray.
I do have one question. So your comment that if you had been involved in writing the decision on McNaughton versus
Chartier. Mm-hmm.
You would have added your own interpretation. The most important thing on a court of appeals is to decide the facts of the issue in front of you, right?
That's correct.
Okay. But you would have gone on and done something else. And what was it you intended to do?
Sure. So Commissioner Gray has asked a very, very important question, and I want to make sure I'm clear on this. Our first task is to resolve the case, clearly. But in cases where that opinion can provide guidance to lawyers as far as what that area of the law is, I think it's amazing what a couple of sentences or a paragraph can do to provide guidance to future attorneys. And so I'm hesitant to get into the merits of that case, but I did bring the case, and perhaps it will be clear if you read this. The question is, what are lawyers to do with respect to easements that don't have this particular language? Can there be an easement that doesn't have this magic language that it runs with the land, and it still actually run with the land? Well, if you get to your house because of an easement that doesn't have this language, suddenly this case is very important.
But don't you run the risk, if you are one of the judges on the Court of Appeals, and you have a 3-judge panel, and you issue this, that this might not be this extra language, this extra interpretation, may not be necessary for the case? Don't you run the risk of stepping in on other people's areas? I mean, that's a concern for me.
Yeah, so it's a fair question. So I do a lot of continuing legal education work. That is a setting where I give guidance to lawyers as far as what is the law and practice pointers. Mm-hmm. That's in that box. But you and I both have read cases where you can understand the court's rationale and their outcome, but there was guidance in there for future attorneys that to read that case and know how to better apply it. And that's all I'm suggesting, is that because of the lenses that I bring, I can help provide guidance for attorneys who were asking to rely on this. This case, it admittedly left some ambiguity in terms of how to apply it. And they just didn't realize, I think, the challenges that people like me are going to have to deal with in applying this case. It created some questions as much as answering some questions. So that's my goal.
And Mr. Gartin, one of the things that could have been done, though, is they could have said, here is an issue where there's some ambiguity. We asked the legislature, we've seen this many times. This is an issue the legislature should deal with, and they put those in the opinions. I've seen that happen too.
And I think that's a very appropriate thing to do. Again, this goes back to my point about not trying to be a quasi-legislator. And I think that, we're seeing some really wonderful concurring opinions now within the Supreme Court and the Court of Appeals, where I think there's some liberty to provide that kind of commentary. But I appreciate very much you taking the time to ask that question, because I do see the difference between a continuing legal education event and a Court of Appeals decision. I understand that difference.
Thank you, sir.
Thank you for asking the question.
Well, thank you. Our time is up, and thank you for your application, Tim, and we wish you the best of luck.
Thank you very much for your service.